Welcome to the federal court system. So we have in America what's called a dual court system. That means we have federal courts and we have state courts. And you might remember this from when we did the chapter on state and local government that we kind of talked about this dual court system. So now we're going to focus on the national part of the judiciary, the federal part. Okay? All right, so under the Articles of Confederation, there was no national judiciary. There were no national courts. And so the conditions under the Articles of Confederation were such that the states interpreted and applied the laws as they saw fit, or they didn't, right? Every state managed their own affairs, whether the methods contradicted the methods of other states. And when the methods did come into conflict with other states, they were left to decide all on their own. Right? So just like I've used the comparison before of siblings arguing, states just argued with each other and it didn't always go well. So the framers of the Constitution recognized the need for a national judiciary, and they created or they incorporated Article 3 in the Constitution. If you remember from the classroom, Article 3 of the Constitution is relatively brief, much smaller than Article 1 and Article 2, and that's because they just wanted to set up that there would be one. The only court mentioned in the Constitution is the Supreme Court. It's the only one that was created. And then the power to create the lesser courts was left for Congress, that Congress could create any inferior courts that may be necessary. All right, so the judiciary created by the Constitution is passive. It has to be brought into action through people's actions. Citizens or even states can bring forth their issues or their problems to the courts for the courts to decide. The framers wanted the judiciary to be independent, making sure that the justices would receive an income and that they would serve for life. They would not be beholden to the president for their jobs, but could be removed for misbehavior or malfeasance. So if they do not act properly or according to their job descriptions, they can be removed, but they can't be removed just because the president doesn't like the way they rule or Congress doesn't like the way they rule. Okay. So, like I said, Congress is given the express power to constitute inferior courts. This only applies to federal courts. States have all control over state courts. Okay, so the federal government controls the federal courts, and the states take care of the state court system. They're very similar and they're parallel, but separate also. All right, so these are types of federal courts that are established, that are hinted at in the Constitution. But like I said, only the Supreme Court is created. So we have district courts and courts of appeal, and pretty much those are the only ones that we're going to focus on. But there are other courts, and some of these courts are created by, well, in fact, all of them were created by Congress because only the Supreme Court was created by the Constitution. And all of these courts were created as needed, right? So the Supreme Court, I mean, there are hundreds and hundreds of thousands of cases go through the court systems today. So there's no way the Supreme Court could handle all of them. All right, so special courts are created by Congress, and they hear cases arising from expressed powers. So remember Article 1, Section 8, all the express powers of Congress. Congress, as needed, created courts to deal with issues. So there is a tax court based on Article 1, Section 8, Clause 1, the power to tax. There needs to be a tax court because there are cases that deal with taxes. All right. And obviously they have a narrower range of cases than the other courts. They're specific to their topic, but there, like I said, there are just hundreds of thousands of cases. So sometimes these are called legislative courts because they're created by Congress. All right, so jurisdiction is basically what jurisdiction means is the authority to hear a case. And this is an important concept because it affects which cases get heard by which courts, right? Not all cases can be heard by all courts. So the first tier, the first distinction is whether it's a federal matter, and if it's a federal matter, it goes to federal courts, and if it's a state matter, it goes to state courts. But there are other jurisdictions also, and so it's important to have that distinction so you know which cases are going to hear which courts are going to hear which cases. So you already heard me say there's a U.S. tax court. They're obviously going to hear tax cases. So federal court jurisdiction cases that are going to go to the federal system have there are certain qualifications that make them able to be heard or give the federal court jurisdiction over them, the authority to hear them. Okay, so exclusive jurisdiction applies to any case that can only be heard in the federal courts. Concurrent jurisdiction applies to any case that can be heard in both federal and state courts. Okay, so original jurisdiction applies to any case that's heard for the first time, and these are typically heard by district courts. In the state system, we call them trial courts. And then appellate jurisdiction applies to any case that's being heard on appeal or any time after the original hearing. And these words actually should sound familiar to you because we talked about these when we did the state and local government. All cases that are not heard by the federal courts are within the jurisdiction of the state courts. Okay. So federal court jurisdiction is determined by the subject matter of the case or the parties involved in the case. And we find this described in Article 3, Section 2, Clause 1, if you want to go to the Constitution and look it up. Okay, so depending on what the subject matter is, what the case is about, or who the parties are, involved in the case, who's bringing forth the case and who's defending the case, it might be federal court jurisdiction. Right, so these are the different subject matters that make it a federal jurisdiction. If the case is about any of these things or subjects, then the case will be heard by the federal courts. Now, in some circumstances, the case may be a concurrent case, which means the states may also hear it. Okay. So maritime law, always federal. Question of admiralty law and the high seas, always federal. And then interpretation and application of a provision in the Constitution or any federal statute or treaty makes it federal. Now, the parties involved, again, if the case is brought forth by any of these people or the defendants is any of these, then the case is a federal case. Okay, in some cases, when a state sues another state, it can be heard in state court. So again, okay, so parties involved. I'm sorry, I want to make sure you see there are these three on this slide for parties involved, and then these three for parties involved also. Okay, and any of those makes it a federal case. And so you know that phrase, don't make a federal case out of it. That federal cases tend to be the more severe. Okay, and then again with the types of jurisdiction. So like I was saying about concurrent cases where they can be federal or they can be state. If it's diverse citizenship, meaning that the parties in the case, the defendant and the plaintiff, are from different states. If it's over 75,000, if the case's value is over 75,000, then it can be heard in federal courts. Okay, so that's what diverse citizenship means. A case that involves more than one state. Okay, appellate courts do not retry cases. They look at the original case and the verdict to determine if due process was followed or violated. Appellate courts can uphold a verdict, which means that whatever the lower court decides or whatever they had decided stands. They can overrule or nullify a verdict, and that means the appellate court has decided that the original verdict is flawed in some way and should be reversed. And then the court can modify a verdict, trying to correct whatever was determined to be wrong, or the court can remand it back to the lower court for the lower court to have further proceedings to fix what might ever, whatever might have been determined to be wrong. Okay, so it's different things that the appellate courts can do. Again, they do not retry cases. They are looking for any mistakes that may have been made in the original case. Okay, and so there are no juries in appellate courts. It's a bench trial, and usually more than one judge will hear the case. Okay, so appointments, and primarily we'll talk about the Supreme Court, but many federal court judges, all Supreme Court justices are appointed by the president. The president picks the judges and submits their names to the Senate, and then the Senate Judiciary Committee, as part of the constitutional checks and balances, will investigate the person and will determine whether they want to okay them for confirmation, and then they submit their findings. The Senate Judiciary Committee will submit their findings to the whole Senate, and then the whole Senate, again, as part of checks and balances, must confirm the appointment before the judge or justice may take the bench. Okay, there are 94 district courts, and all of them are appointed. All of those justices that serve in those 94 district courts are appointed by the president. Okay, so since the district courts are within the states and the positions are filled with judges from within the state, there's this practice called senatorial courtesy. So when senators are voting for confirmation, they typically will look to the senators of whatever state's position is getting filled. And if that state senators approve of the appointment, then the senators typically give the go-ahead for that appointment. Okay, so like if Michigan needs some district judges, the 100, the 98 other senators will look at Michigan's 2 senators to see if, Michigan senators approve of the appointment. It doesn't always work like that, but there is, like I said, there is this senatorial courtesy. Hopefully, Michigan senators know Michigan's judges and will have an idea, if they're going to make good appointments or not. Federal judges that are appointed for life. They can be impeached just like any other federal official, but as long as they are serving in good behavior, then they get to keep their position. All right. Now, when a judge is on the bench, there is, they obviously are interpreting and applying some, provision of the Constitution or an act of Congress. So they're helping to shape public policy. And so there are these 2 theories, judicial restraint and judicial activism. Right? So when the courts are determining the constitutionality of any law or action of the president, the judges are deliberating their decisions on cases. They typically will practice judicial restraint or judicial activism. The judge tends to just look at the case, the original intent of the Constitution, the enacted law. They may look at precedent, but they try not to make law. They just rule on the case according to precedent, things that have already been determined, and actual intent or original intent of the Constitution and of the law. Judicial activism is more of an idea of if the ruling is going to create a situation that is bettering for people, or will better a situation, it's creates better public welfare or good welfare, then they may not restrain themselves, but they may be active in their ruling, right? So it's kind of this idea that they're active in determining law, and that laws should be interpreted and applied in light of society. And so if they need to change or be a little more, look at the spirit of the law, then that's judicial activism. Okay. All right. Constitutional, like I said, constitutional court judges who are appointed for life. This is to ensure the independence of the judiciary. They can be impeached. The special courts, they can be elected or appointed, appointed for terms. Okay, and so they might serve varying terms. All of them have a generous pay and retirement, and that's all set by Congress. All right. So the independence of the judiciary was seen as the most important step in making sure that this branch of government would not become oppressive or corrupt. Right. Once appointed, they serve, for good behavior, for life unless impeached, and that's any justice that's appointed, and that's pretty much to keep them separate from politics. Right. They don't have to worry about people agreeing with what they're doing or what they're not doing, or the president agreeing or not. They're going to hold their position for life. These are other federal court officers, so there are lots of people involved in the judicial branch that are not just judges. So magistrates perform duties that the judges would normally have done, so they're breaking up the workload, or dividing the workload. Bankruptcy judges, U.S. Marshals, U.S. attorneys, just a lot of people in the judicial branch, not just judges. Okay. All right, so you should remember these terms. Prosecution, plaintiff, those are the people who bring forth a case. And then the defense, the defendant, those are the people who defend themselves. This doesn't necessarily mean that either side is innocent or guilty. It's just about who brings forth the case and who defends in the case. Now, in a like crime like murder or rape, the plaintiff is the prosecution. So the state, meaning the government, will bring forth the case. So you're going to see Michigan be the prosecution, or the U.S. government, the United States, be the prosecution. In